Hi everybody, Ahmad Sadiq from Land Trust Title of Central Florida. Let's talk title. Today I want to talk about a very important aspect of what happens at the closing table and ultimately who needs to sign when we're dealing with sellers. And we deal with this issue often where we'll have real estate agents that are working with their clients, and their clients will tell them, yes, my spouse and I, we're no longer together. And ultimately, the assumption is that when they say that they're no longer together, that they're divorced. And there's an important aspect when we're talking about property that's held, that's marital property or tenancy by the entirety property, where ultimately if we determine during the course of the transaction that the person who's on the contract is a married individual, legally still married in the state of Florida, the law assumes that you're married and you're happily married until the moment that there is a dissolution of marriage is filed in public records. So ultimately that means for us that even if one spouse is signed onto the contract, all of the addendums, when we get to closing, we need to have both spouses that are going to be present, or at least both spouses that need to sign off on generally the settlement statement and on the warranty deed as well. Otherwise, we're going to deal with the title defect down the road, where an underwriter is going to say, it looks like this property was not properly transferred, and actually half of the interest of the property is in the name of the new buyer, but the other half of the interest is still in the name of the spouse who never signed onto the documents. So what does that mean? As real estate professionals, as real estate agents, for you guys, when you are taking your listing appointments, it's important to have that additional conversation with your client. And that is, if they're telling you that they are no longer married, it would behoove you as real estate professionals to go that additional step and say, well, when was it that you officially got divorced? And it would even be better if you were able to get a divorce decree from them, because ultimately if they are divorced, as a title company, we're going to need the divorce decree, and we're more than likely going to need a copy of the marital settlement agreement that specifically talks about division of both tangible and real property. And if they're not divorced, regardless of whether they've been separated for a very long period of time, we've had clients that have come in that have been separated from their spouses but not legally divorced for 15 years, that doesn't negate the requirement that that spouse needs to come in and sign on the deed, or at least we need to send a notary out to them so that they can sign. Otherwise, we're going to deal with the title defect. Otherwise, the property is not going to properly vest fully in the names of the buyers when they purchase a property. So make sure you're having these important conversations with your clients at the listing appointment so that we're not getting to the closing table only to realize that there's an additional person that needs to sign. And if your client hasn't had conversations or been in touch with their spouse for a very long period of time, it may take some time for us to be able to get in touch with them and then get them to sign the documents needed to actually effectively transfer the property from the sellers to the buyer. So have these important conversations with your clients up front so that we don't deal with issues when we get to the closing table. Guys, again, thank you for your time. Looking forward to seeing you next time.